Good morning, everyone. My name is Richard Ponte, and I am the Director of Events and Programs for the Maine State Chamber of Commerce. On behalf of our entire team here, it is my pleasure to welcome you to our Human Resources Update, the latest in our webinar series. Thank you so much for joining us. Before we get going, there are just a few things we'd like to share with you about today's session. If not presenting, please turn off video. And to reduce background noise, all participants will stay in listen-only mode. Please stay on mute to reduce noise. And please submit questions in the chat panel addressed to everyone. And towards the end of the presentation, we will go through, moderate them, and just rifle through them one by one. We will also use the chat function to share useful links and other materials. And the meeting is being recorded, and we will make the recording available to you on our website in the next few days. And finally, if you lose your connection, please use the same Zoom link to reconnect. So with that out of the way, we would like to now begin by thanking our sponsors. Our premier sponsor this morning is MEMIC. Our program sponsor is Littler Mendelson, PC. And our 2024 webinar series sponsors are AARP, Central Maine Power, Northeast Delta Dental, Kennebec Savings Bank, and Sun Life Insurance. I will now turn it over to Rob Atkinson, who will provide some remarks on behalf of today's premier sponsor, MEMIC. Rob serves as the Director of Marketing and Public Relations with the MEMIC Group. We are happy he is here with us today. Good morning, Rob.
Thank you, Richard, and good morning. It's an honor to address such a distinguished gathering of HR professionals from across Maine. And for those unfamiliar with MEMIC, we're a workers' compensation insurance carrier dedicated to promoting workforce safety and effective injury management. And if you didn't know, MEMIC stands for Maine Employers Mutual Insurance Company. So that mutual part has great meaning. That says that we're owned and governed by our policyholders that include many of you here on this call today. And of course, the other 17,000 small businesses spread across every county in Maine. MEMIC is often referred to as that Maine miracle. Before MEMIC, workplace injuries were rampant, legal battles raged, premiums soared, making Maine the most expensive state for workers' compensation. And I'm proud to say in the 31 years since MEMIC's formation, lost time injuries in Maine have been cut in half, and the overall cost of workers' compensation insurance has been reduced by a dramatic 60%. In addition, this year alone, MEMIC returned $18 million in dividends to our Maine policyholders. And these dividends really serve as a tangible reminder of how our safety partnership yields significant returns for our policyholders, with, of course, that added benefit of stimulating Maine's economy through investments, wages, and job growth across all of Maine's 16 counties. But unfortunately, our work is far from done. I hope you had a moment to read Richard's email he sent out with the MEMIC attachment last night. We want to bring your attention to proposed legislation that really could have profound implications for your business and the future of workers' compensation here in Maine. We believe it's important to stay informed and engaged to ensure your voice is heard in shaping these important policies that impact us all. So with that, thank you for your time this morning. And together with your help, we're going to make workers' compensation work better for all Maine businesses. Richard, again, thank you for the time again this morning.
Well, thank you for sharing, Rob. And again, many thanks to MEMIC for their sponsorship. It is now my pleasure to introduce Jacob Lachance, who is a government relations specialist with the Maine State Chamber of Commerce. Jacob will be leading and facilitating the conversation today. Good morning, Jake.
Good morning, Richard, and thank you everybody for attending this HR update. As you'll see, there's a lot of work that was done over this past session here in the state, and a lot of work done federally in the realm of labor and HR legislation. I'm really happy to have both Mindy Caterine and Steve Silver here with me today from Littler Mendelson. Mindy is our policy chair for the Maine State Chamber of Commerce as well for the Labor Committee, and has been an extraordinary help to me over the course of this past session to really help hone in the chamber goals and get things done on the state level. Mindy represents management and employment disputes before federal and state courts and agencies throughout New England. Practice includes defending employers in matters involving sexual harassment, employment discrimination, retaliation, wrongful discharge, and employment contract dispute cases. Mindy also conducts training on numerous employment issues, such as harassment, wage and hour compliance, reductions in force, leaves of absence, and discipline and discharge. In addition to her practice, Mindy has taught a course on employment discrimination as an adjunct professor at the University of Maine School of Law. Steve Silver, also of Littler Mendelson, focuses his practice on ERISA litigation, sports and gaming law, and representing employers in federal and state court litigation involving discrimination, harassment, retaliation, and wrongful termination claims. He also represents employers in administrative hearings and counsels employers on a broad spectrum of day-to-day employment matters, including employee discipline, termination, leaves of absence, COVID-19 reopening protocols, and wage and hour issues. In addition, Steve assists employers in drafting policies, employee handbooks, and employment-related agreements to ensure compliance with local, state, and federal law. So thank you so much to Mindy and Steve for joining me today.
And thank you. Before we jump into the content, we've got a lot today. I just want to tell you all a little bit about Littler Mendelson. We are the largest boutique of labor and employment lawyers in the world. And so we've got 1,700 attorneys across 100 offices, and all we do is labor and employment issues representing the management side. Within that, of course, there's a lot of different specialties in industries we serve, and this is just a list of some of what we can help you out with. There's certainly no shortage of changing labor and employment laws, both in Maine and federally. We've got offices all over the country and attorneys admitted in all 50 states. And then, of course, some offices around the world as well. So really, wherever you are, wherever you've got employees, we've got someone who can help you if you've got a need. And then right here in Portland, in our office, we've got a great group of attorneys, who cover the whole state. Mindy obviously is pretty enmeshed with the state chamber and helping up there in Augusta. So whatever your labor and employment needs are, we can certainly help out. And then one thing I'd encourage everyone to do today, it's totally free, is go to this link at the bottom, littler.com/subscribe. You can pick based on industry, jurisdiction, topic, and subscribe to publications, that include legislative updates, case law updates, all sorts of things. And we have a great publications team that puts those out totally free. And we'll keep you up to date on everything, because as you're going to learn today, there are rules and laws that are changing very rapidly. So with that, I'll turn it back to Jacob to sort of go over what was quite a busy legislative session this year.
Yeah, thanks, Steve. So just an overall agenda for this forum here. We're going to touch on the second session here in the state of Maine, as well as newly enacted laws, major federal rule changes, and recent court rulings. First, the legislative update here in Maine. Over the course of the 131st Maine Legislature, in the first session ending in June of 2023, our legislature was very active. There was about 2,200 bills that were introduced, with 639 passed into law. The effective date for this legislation passed during the first special session was October 25th of 2023. About 400 plus of those bills were carried over into the second regular session, which operated from January to May this year. One thing that was really prevalent in this second session was the amount of concept drafts that were carried over. And I think it's pretty safe to say that the overall procedure of the legislation was really, really marred by these concept drafts. These are pieces of legislation that were carried over in title only, that really didn't give anyone involved at the State House any idea of what these bills were going to be. There was no bill language associated. Sometimes leading up to days before a public hearing. And there were multiple instances where full bill language was introduced right before a public hearing, or even drastically changed, if not completely overhauled, within days, if not hours, of a work session. There was 197 new laws that were introduced for the second regular session, and the effective date for all the legislation passed during the second regular session is August 9th of 2024. We're going to touch on some chamber successes that happened really over the course of the second regular session. This is a smattering of bills. As those of you that were in the State House know, at the end of this session, there were some really unprecedented procedural things that went on in terms of how bills ended up dying or not being taken up at the end by the end of the session, which resulted in a handful of bills really not being dealt with at the end of the day. LD 513, an act regarding overtime protections of certain Maine workers. This is a bill that was not moved off the appropriations table, but still has pretty significant impact on a federal level. One of the things that we've seen with multiple bills in this past session is both the governor and the legislature waiting for federal rulings to come out on the same topics. This is one of those instances where the overtime threshold multiplier was going to be changed, attempted to be changed here in the state of Maine, but was ultimately ended up changing at the federal level. And according to the federal rule that came out, the current minimum salary in Maine is $816.35 per week. Coming up July 1 of 2024, the federal rule states that the minimum increase will be to $844 per week. And on January 1 of 2025, the minimum increases to $1,128 per week. One of the things that we lobbied for this bill in the state was that there should not be a drastic increase in this threshold to give businesses a chance to set budgets, make sure things are squared away. And unfortunately, with the federal rule, that's something that was not really taken into consideration. And in that jump, starting on January 1, 2025, increasing that to $1,128 per week is a really significant jump. And that's something that businesses should really be taking into account over their next budgetary session. LD 1464 was an act to remove the waiting period for benefits under Maine's unemployment insurance system. This was voted down in the Senate. The waiting period is really important for the unemployment insurance system, as a lot of people within that 1 week waiting period often find another job, so benefits would not be paid out to them. This would have been a very significant increase, and the Maine Department of Labor estimated that the fiscal note for this bill would have been anywhere from $8 million to $40 million. So we were really happy to see this bill get voted down in the Senate. LD 373 was an act to ensure employer and employee harmony agreements in clean energy projects. This movement of inserting concerted activity, PLA, employer harmony agreements is something that was really prevalent starting kind of in this last session, and has been over the last few sessions, of getting the union language attached to a bunch of these projects. We thought there was union language that was inserted into another Northern Maine transmission line bill that was taken up in another committee. And it's something that's really, at the end of the day, kind of anti-Maine worker. Right now, the Maine workforce is not comprised of a high percentage of union workers, especially for the construction and manufacturing jobs. And shifting that, or mandating a shift to that, really kind of makes Maine workers an outlier, because they're not a part of that population. That would either force businesses to become unionized, or not be able to bid for these projects in the RFP process, where these RFPs are requiring some sort of harmony agreement or PLA included in them in order to be awarded these RFPs. Very thankful to the governor's office that we worked closely with on this to get this bill vetoed. So thank you to Governor Mills for vetoing that bill, and as well as the House for sustaining that veto. LD 1794 was a bill that kind of took different iterations as the session went on. It really started as a standalone bill, but moved to a resolve and a study that really would have singled out pulp and paper manufacturing facilities in terms of the predictability of mandated overtime. We worked closely with our chamber member, Snappy, to really attempt to get this to a place that was workable for them. And we thought it was really unfair for the pulp and paper manufacturing facilities to be singled out with this piece of legislation. That bill was placed on the special study table and was part of those groups of bills that ended up not being ultimately taken up at the end of the session. It is important to note for a lot of those bills, while right now we do consider them dead, the technicality of whether or not the legislation has actually died, or if they can be taken up in a special session that is going to be that could happen in the future. It's really we haven't had any indication that special session is going to happen or is going to be taken up, but we are still on the surface of things paying attention to these if that special session does pop up. Again, we've had no indication that that's going to be the case. LD 2273, an act to establish a state minimum hourly wage for agricultural workers. This was also vetoed by the governor in conjunction with LD 525, which is an act to protect farm workers from allowing them to organize for the purposes of collective bargaining. Again, these were both vetoed by Governor Mills and sustained in the House. And LD 2273 specifically was a bill that really took a lot of different turns throughout the committee process, especially in relation to private right of action language that was ultimately opened up by the committee in the Labor and Housing Committee. This was something in conversations that we had with the governor's office that I can fairly confidently say she wasn't overly thrilled with, especially after the stakeholder group had spent many meetings and many hours working on this bill to get it workable for everybody. Again, very, very big thank you to Governor Mills for ultimately vetoing both LD 2273 and LD 525. In terms of bills that were ultimately passed and enacted, during this session, we saw the posture of the Maine Department of Labor really hone into proactive enforcement in terms of how they are going to be going about wage and hour violations. Historically, wage and hour violations would be filed based on a formal complaint made to the department, and they would go about their process of assessing whether or not the business did in fact have wage and hour violations within their scope of work. There were two major pieces of legislation that ended up passing in relation to the department's wage and hour enforcement. The first was LD 2184, which is the Chapter 9 rulemaking, which increased the fines for unpaid wage violations to up to $1,000 per violation. There are still multipliers within the Chapter 9 rulemaking that gives businesses a chance to have that fine reduced, but the minimum fine really kind of aligns with the posture of using fines and violations as a deterrent to Maine businesses for having these wage and hour violations. This is something that we worked with the department. We had many conversations with them about both the Chapter 9 rules as well as LD 372, which gives the department the power to order back wages, fines, liquidated damages, interest, to be able to order those to be paid without um, being able to go through the adjudication process through the court. This is a change that on the surface we were really concerned about, just because we were worried that there wasn't a chance for businesses to get a fair shake in these types of situations. There is a method of appeal that would go through the department for these wage and hour violations, but giving the department the ability to just order back these things is definitely a change based on past precedent with not involving the courts. We had many conversations both with the department and representatives from the governor's office about this bill. I do want to thank both the department and the governor's office for at least having those talks with us, even though we ultimately didn't come to a conclusion that really satisfied, I guess, the business community. But I think there was a lot of good talks within this that allowed the business community to voice their opinions and recommendations about these pieces of legislation. As you can see with the slide, there was testimony from a representative of the Department of Labor. We want to go towards proactive investigations, where we can go to the employers that we suspect, even if a worker does not complain. We've heard that this could be in the manner of anecdotal stories and anonymous tips for businesses in terms of wage and hour violations. So what we attempted to do in the end through these talks with the department and with the governor's office is say, listen, people should be getting the money that they deserve in terms of wages. 100% agree with that. That's hard-earned money that should be in their pockets. But we don't feel as though the businesses that are making one-off clerical errors, one-stop HR shop, where mistakes are really bound to happen just with the capacity that they have to deal with things within their business. They shouldn't be on the same playing field as folks that are intentionally keeping wages over an extended period of time from their employees. So what we attempted to do was insert amendment language that would give a goodwill clause for employers, saying that the DOL would have to prove that goodwill did not exist with these wage and hour violations. That vote came down to 2 votes in the House, and ultimately was not successful. But we did a lot of work to try to ensure that playing field is really appropriate for what is happening within the business community. One other thing that I do want to bring up that also passed that is not necessarily up on these slides is there was a piece of legislation in reference to the Workers' Compensation Board, which is LD 1896, which is a study that is looking at benefit adequacy within the workers' compensation benefits. This is something that was originally taken up and worked back in 2019, was the last kind of overhaul to workers' compensation. Even since 2019, Maine is the 6th most expensive state in the country in terms of workers' compensation benefits. This is something that the chamber is really looking to lower the cost for employers, as they're the ones footing the bill for workers' compensation benefits. And this study, really looking forward, I think is going to be setting the groundwork for a lot of legislation that's going to be happening in this upcoming session. We are continuing talks with the Workers' Compensation Board as well as Executive Director John Rohde, to ensure that things hopefully stay within reason in terms of the benefits the Maine employers are going to be paying in relation to workers' compensation. One of the other bills that was vetoed by the governor, again, very appreciative to Governor Mills for that, was LD 1496. This was a bill that would have heavily restricted, if not banned, non-compete here in the state of Maine. They did pass both the Senate and the House, and went to the governor's desk, and he vetoed it on March 29th of 2024. And the legislature sustained that veto, which we are very fortunate for. In the veto message from Governor Mills, she stated that non-competes can be a critical tool for employees for taking unfair advantage of their former employers. And Governor Mills said it would be ill-advised for Maine to weigh in until the FTC reveals their rules regarding the same issue. This is another one of those issues, much like the overtime threshold, that Maine was really kind of ahead of the curve, or attempting to be ahead of the curve in terms of passing state legislation before any type of federal guideline. So ultimately, Governor Mills did veto that bill, which we were very fortunate for, as we had a lot of businesses reach out to us saying that this is something that would not be workable for them. Unfortunately, towards the end of the session, the FTC did rule 3-2 that their own non-compete rules, and I'll kind of turn it over to Steve to touch on what the FTC ultimately ended up ruling on.
All right. We've got a ton to cover. We are going to go sort of rapid speed, given the time remaining. But these slides will be available, I believe. So, as Jake alluded to, shortly after the governor's veto of Maine's non-compete ban, that the Federal Trade Commission unveiled their own ban. There has been a suit filed. It's down in the U.S. District Court for the Northern District of Texas. A briefing schedule has come out. So actually 1 week from today, the FTC's response is due. There's supposed to be a hearing in mid-June, and the court said it'll issue a decision by July 3rd. Whatever the decision is, it's probably not going to end at that court. I suspect it'll go up on appeal and may make its way all the way to the U.S. Supreme Court. But if this goes into effect, it takes effect in September. And it bans essentially all non-compete agreements. There's some exceptions. We'll talk about them, mainly for senior executives or related to a sale of a business. The other key piece of this is that there is a notice requirement that employers will have to send to both current or former employees who are subject to non-compete agreements that are now effectively banned under this. So this is what we're talking about when we talk about a non-compete. This is how the FTC defines it. So restricting the ability to work in a certain field or operate a business. This again covers employees, contractors, interns. I mean, everything under the sun. And of course, you know, they put in that it should supersede all state laws and regulations. That's the floor. States can certainly go above it. I'm not sure what else a state could do to make it stricter. This is pretty strict as it is. So what about your agreements that are already in place? Unless the individual subject to that agreement is a senior executive, talk about what a senior executive is, they're effectively banned. And not only are they banned moving forward, they're banned looking backwards, meaning you have to give notice to workers, former or current, who are subject to this. The rule only says it has to be in written form. It even says you could send a text message. I'm not sure I'd recommend doing that. Probably better to put together a letter or an email. But there is some model language if you go to the FTC's website in terms of that notice. So now is really a good time to take stock of what agreements do you have out there? Are there non-competes in there that are now invalid if this rule takes effect, to figure out who you have to give notice to? And so we talked about senior executives. This is important because pre-existing non-competes with senior executives are not invalidated. They would still stand. But it's a pretty narrow definition. You've got to meet this salary threshold and be in a policy-making position. The rule says that's a president, CEO, or someone with equivalent policy-making authority. We expect that there will be a lot of fights about who qualifies as a senior executive. The FTC estimates that less than 1% of workers are senior executives. And so the sort of vague definition of what policy-making authority means, I think will be the subject of some disputes moving forward, particularly because at that level is where we often see litigation about non-competes for those top executives. Now that doesn't mean you can't have some other types of restrictive covenants, right? The FTC recognizes that you need to protect your confidential information, trade secrets, maybe non-solicitation of current employees. But it's going to be a, quote, fact-specific inquiry. And again, that will leave room for debate and probably fights as this moves forward if this ban actually takes effect. The biggest carve-out or exception to this is if a non-compete involves the sale of a business. That's pretty typical. That's what Maine's law would have had an exception as well. And then if you have a current issue with a non-compete, let's say you're in litigation right now, the regulation won't make that go away as long as it's prior to that September effective date. There is what's called a good faith exception. Again, that will be the subject of debate, what was and was not good faith. So, practically speaking, businesses should be operating as if non-competes are banned. This won't take effect until September. We'll see what the courts do. Obviously, if there's a change in administration and after the election in November, this could all go away. But it's a really good time to go ahead and sort of conduct an internal audit, so to speak, of what agreements do you have out there, right? Not just current ones, but prior ones. And do they contain these? Because you don't want FTC, the DOL, the NLRB getting a hold of prior agreements and saying you're violating this. And then how many people have to be notified? Is it only a couple? Are they actually senior executives, or are we sending out 1,000+ notices? So this summer for some homework, that's what I'd recommend doing until the courts rule if this is going to go into effect. And so now that I've scared you a little bit, I'm going to turn to Mindy to scare you a little bit more about what's gone on in Maine since the last HR update, which was last spring, and we had some things take effect in the fall.
This past year, the legislature increased the caps on compensatory and punitive damages under the Maine Human Rights Act. Compensatory damages are things like pain, suffering, emotional distress, loss of reputation. Punitive damages are for acts of malice or reckless indifference to an employee's protected rights. And in Maine, an employee has to prove punitive damages by clear and convincing evidence. So in terms of the caps, for a small employer, the caps were, and a small employer is between 15 and 100 employees, the the caps doubled from 50,000 to 100,000. For medium-sized employers, 100 to 101 to 200 employees, the caps tripled from 100,000 to $300,000. And for large employers, more than 500 employees, the caps doubled from 500,000 to $1 million. So obviously a lot of money, big increase. And on top of that, plaintiffs are allowed to stack the caps under federal and state law. So for large employers with more than 500 employees, the cap would be $1.5 million. So we're talking big bucks. So if you have employment practices liability insurance, you may want to check your policy to make sure that you have adequate coverage. And we've also seen an expansion of Maine's Equal Pay Act. Under Maine's Equal Pay Act, employers may not discriminate against employees on the basis of sex when comparable work is being performed. And as of June 22nd of 2023, the Maine Equal Pay Act was expanded to provide that employers may not discriminate against employees in pay on the basis of race when comparable work is being performed. And comparable work means comparable requirements related to skill, efforts, and responsibility. However, the law is silent on the issue of quality and quantity of work. And that really gives me pause because a lot of times people are compensated based on the quantity and the quality of the work. So you really need to revisit, how you're compensating your employees and whether or not there is any difference based on gender or sex. In a recent federal case, the federal district court held that employers are strictly liable for Equal Pay Act violations on the basis of gender and potentially race under the Maine Equal Pay law, regardless of an employer's discriminatory intent. And this decision was appealed to the First Circuit. And in February of this year, the First Circuit affirmed the decision of the federal district court. And as the saying goes, bad facts make bad law. It's undisputed that in this particular case, the hospital paid 2 male psychologists $95 an hour, while it paid a female psychologist $50 an hour for the same job with the same qualifications. And under the Maine Equal Pay law, an employer may not discriminate between employees in the same establishment on the basis of sex by paying wages to an employee of one sex at a rate less than the rate at which the employer pays an employee of the opposite sex for comparable work on jobs that have comparable requirements relating to skill, effort, and responsibility. So in a 2-to-1 decision, the First Circuit held that there is strict liability under the Maine Equal Pay Act, and there is no need to prove discriminatory intent. Under the Maine Equal Pay law, differences in pay are not prohibited if they are done as a result of an established seniority system, a merit pay system, or shift differentials. Otherwise, pay must be equal for comparable work. And again, this applies to both gender and race. And importantly, I want to note the distinction between this standard and the standard under federal law. The federal Equal Pay law allows for a difference in pay based on quantity and quality of work. And it also allows for a differential based on any factor other than sex. So the Maine law is much tougher than the federal law. So when you're deciding on compensation, you need to be mindful of both the federal and the state law. In its recent decision, the First Circuit expressly rejected pay differences due to market factors such as paying bonuses or premiums to attract talent from other geographic regions, or an individual's ability to generate business. And oftentimes, even in our practice, you see compensation being driven based on an individual's ability to generate business. So you need to really look carefully at how your employees are being compensated. And the penalty for a violation of the Maine Equal Pay Act is treble damages and attorney's fees. So it can be very costly, and we are seeing these cases routinely. Anytime that a plaintiff can attach one of these cases to some other type of litigation, they do it. So you may want to consider whether it's time for you to do a pay equity audit.
Yeah, and just the other thing, the other thing we see, which is difficult, is many employers don't know the races of employees, or they're mixed race, or they're not disclosed. And so
Or the
that this,
facts.
yeah, so this notion that, you know, it does discriminatory intent does not matter is really problematic. And this is the result of, you know, the Mundell case moving through the courts and then the legislature amending before Mundell was fully decided. So now we're in a system that really no other state has, with both race and gender being strict liability. So with that, let's scare you some more, and talk about paid family medical leave. Right? This is the, I won't even say 1,000-pound gorilla, 10,000-pound gorilla in the room. So Jake, if you want to set us up where we are here.
Yeah, thanks, Steve. So I want to kind of preface this conversation as well to the fact that the rules for the Maine paid family medical leave were released this past Monday morning. So we've had about a day and a half maybe to kind of digest those. Going forward, we are going to touch a bit upon some discrepancies or changes from the piece of legislation that passed last session to the rules that came out on Monday. But there is going to be a further extensive deep dive by the chamber with another webinar in the near future to really go into what these rules mean, and most importantly, kind of a call to action for really all businesses to take part in the public hearing that is going to be happening here in the near future at the beginning of June. So just kind of getting into things here. Paid family medical leave will provide up to 12 weeks of paid leave per year to all eligible employees in the private and public sector, regardless of employer size. Federal government employees are not eligible within this plan. Leave will be available for employees or family members' serious health condition, birth, adoption, and baby bonding. Safe leave to include sexual assault victim leave and military-related leave. Family includes any individual with whom the employee has a significant personal bond that is or like a family relationship, regardless of biological or legal relationship. That is the affinity relationship that was defined in the rules that were published on Monday. And that's kind of the further definition with who is included. It's going to be funded by a 1% payroll tax split between employer and employee. Employers with fewer than 15 employees are exempt from the employer payroll tax only. So that means that the employees, if you are 15 employees or less, are still going to be paying their share, but the employer will be exempt from the payroll tax if you have fewer than 15 employees. Very important, payroll tax takes effect January 1st, 2025, with benefits being available to employees on May 1st of 2026. Just a overall note here as well, for those of you that have been involved with the Maine DOL presentations that have been done both hosted by the DOL and with us. You will recognize these slides. These were the public slides that were taken from the Department of Labor. All of the comments that we have added, I want to make it very clear that this is not from the DOL. These are things that we included, that we incorporated from the rules that were released on Monday. So I don't want any assumptions to be made or anything that these changes in red are from the Maine Department of Labor specifically. Those are things that we have added based on the timeline of how things are going. So you'll see October 25th was when the PFML law took effect. January 1, 2024 was when the Paid Family and Medical Leave Authority was appointed. The first draft rules were released this past Monday on May 10th, and the public hearing will be happening on June 10th, coming up here in 2024. All comments are due to the Department of Labor on July 8th of this year, and that will be for the first draft of the rules. We can only hope that there will be multiple drafts to these rules as the timeline goes throughout the summer, because there's really a lot of work that needs to be done to solidify and to shore up the rules that were put out on Monday. January 1st, 2025, as stated, rules to implement the PFML program must be adopted by the Department of Labor. Also on January 1st, the payroll withholdings for the Paid Family and Medical Leave program will begin, and on May 1st, benefits will become available. This is just a list of those members of the Benefits Authority. You'll notice that the chair is Maria Fox, a lawyer at Murray, Plum and Murray, as well as Sam Height being elected vice chair of the authority. If you go on the Maine DOL website, there are certain stipulations that each slot for the authority had to abide by in terms of small business, large business, representing employers, representing employees, etc. And you are able to view those on the Maine Department of Labor website. Contributions, again, this could be redundant information for people that have been involved in the webinars, but we wanted to make sure we covered it here as well. Contribution per employee is 1% of an individual's wage rate, split between the employee and the employer. Employers with fewer than 15 employees are exempt from the employer share of contributions, but they must still withhold 50% of the premium from their employees' wages. Self-employed individuals who opt in are only responsible for the 50% premium rate. Example of contribution breakdown for employers and employees. So for employers with 15 or more employees, with an annual payroll of $1 million a year, the annual premium would be $10,000, that being 1% of the 1 million. The employer would contribute $5K, and the employees combined would contribute $5K per year. For employers with less than 15 employees, if an employer with annual payroll of $250K, the annual premium would be $1,250, that being 0.5% of the $250K, and the employer may deduct the entire amount from the employee's wages and would be responsible for remitting the premium.
All right, thanks, Jake. And you know, something to also add in, although there is an employer and employee portion, the employer can choose to pay the employee portion. Well, that's going to be up to each employer, right? I'm on the board of a nonprofit. We're struggling right now to decide what to do, right? Because there's only so much money. We rely on donations, and we certainly don't want the employees taking home less pay. But if the organization pays that portion, that money's got to come from somewhere. And then, you know, I live in the town of South Portland. I think I just saw we've got $150,000 coming out of tax money that's going to have to pay for the city employees portion, or the city's portion of this for their employees. So everyone's getting hit with this moving forward. So let's talk about what we've learned from the first draft of rules that came out on Monday. And as Jake said, it's really important to participate, right? You can submit written comments online. You can attend the hearings in person. The authority, right, the DOL need to hear from you all, right? They hear from the chamber plenty, or law firms plenty, but it'd be great for employers of all sizes to get involved. And the first draft of the rules are not that long. I think they're only about 20 pages, so it's not a heavy lift. Sort of shocking how light they were, but as we touched upon, one of the big changes is that leave can be taken. You know, we expect family leave, medical leave. These are all pretty standard, but for this affinity relationship, right, which is defined in that first set of rules as a significant personal bond that is or is like a family relationship, regardless of biological or legal relationship. The draft rules don't go any further as to what that means. They say it's limited to one affinity relationship per benefit year, and that the applicant must provide information designating an affinity relationship, but there's nothing else. So do you just list the name? Do you have to provide more background info? It's not clear. But to me, I'd read that and think that that's a friend or a neighbor, coworker, anyone you want. Um, uh, so it's not clear how this will play out as the rules go through. Types of leave, right? Continuous, intermittent, reduced. The first draft of the rules say that leave must be taken in full days unless there's an agreement in writing between the employer and employee to use shorter increments. But the lowest you can go is in 1 hour increments. So that'd be something if you had intermittent leave. An employee has, let's say, regularly scheduled appointments that they have to go to. Maybe they're only taking, 1 to 2 hours at a time. That can be done, but there has to be an agreement between the employer and the employee for that. So here, in terms of requirement, the rules do provide for some reasonable notice. The draft rules say 30 days written notice is reasonable when possible, but the notice does not always have to be in writing. So I always like to point out sort of training tips, opportunities to get in touch with your frontline personnel, because I can very clearly see a situation where an employee tells their manager, "Oh yeah, I got to take leave for whatever reason," or "so and so sick, I'm going to be out for a month," and then they just fail to communicate that that employee is actually trying to take paid FML. And they don't have to give you any written notice. So that's something to be aware of that's in the rules. Also says medical documentation is not required. All that the employee has to provide is the reason for the leave, the type of leave needed, the anticipated duration of the leave, and any other relevant details. But again, the employer is not allowed to require any sort of specific form or written, notice, at least as the rules are now. And then you can see here some people who are not eligible, including students, a part of the federal work study program. I know that was a question during the legislative process as to how that would affect them. And then we also saw a little bit more about undue hardship in the rules. There is a mechanism for employers to claim that granting the leave would be an undue hardship. Right now, that places the burden on employers to respond to a request for leave within 10 business days. And then we've got some definitions as to what undue hardship is. And at least as of these rules, the authority is going to look at the financial resources of the employer. That's not defined, unclear if that means profitability, just revenue. What does that mean when you talk about financial resources, size of the workforce, and the nature of the industry? And so here are the things an employer is going to have to provide, including a written explanation and the requirement there's been a good faith attempt to work out a schedule. That's not a lot of time to do that in 10 business days. I highlighted that in yellow because that's part of the rules. It could change, right? It could be increased, it could be decreased. But when you figure you've got to put together a written explanation and show that you've had some sort of negotiations with the employee, that's not a lot of time to do that.
Steve, if I could just jump in here real quick. I just want to impress upon the fact about how hard it is going to be for employers to be able to prove undue hardship with the current language of these rules. let alone what the actual capabilities of especially small businesses are, while they're actually busy running their business and trying to keep their doors open, and worrying about scheduling and all the things that these businesses have to worry about. This, like Steve said, in the span of 10 days, I cannot impress upon you how important and really daunting of a task this is going to be for a really large amount of the employer basis. Like Steve said, I mean, nature of the industry, I don't really know how that goes with how they're going to be viewing undue hardship if there's one nature of business that's more important than another, or these are all extraordinarily vague guidelines at this point in time with these rules that are going to be set. And it is not going to be for the faint of heart to try to prove this undue hardship aspect of things.
Yeah. And we'll see. Right? We all sort of have to wait and see what happens with rulemaking. And I'll bring this up later, but I always like to use my own example, right? I have twin toddlers and we have a nanny. That nanny takes 12 weeks of leave. We're stuck, right? It's impossible to find childcare. So what do we do? And I guess I could meet some of these factors, right? The nature is you're caring for my child and the size of the workforce is one. But then do they look at my income for financial resources? Like, how does that work? It's because I'm an employer, right? So it's very unclear how this is gonna play out. Some other important information, and we'll talk about this. It's in another slide, but there's this 120-day job protection, right? So if the employee, now mind you, I'm not sure if we said this, you can hire someone on a Monday and on Tuesday they can go take 12 weeks of paid leave, right? The only carve out is for those employees who have not worked for at least 120 days, they don't have a guaranteed job protection upon return. However, there's also an anti-retaliation provision. Now, if somebody takes leave and you don't bring them back or fire them, the sole reason you did that is because they took the leave. So there's going to be a retaliation claim. It's a protection without distinction. And I raise this. The chair of the authority, Maria Fox, spoke at a Maine State bar event, and she didn't have an answer for it. So that's something that's going to have to be figured out, hopefully in the rules, but it's not addressed in the first draft. The other thing is private plans. There's obviously a growing market for private plans, whether they be self-insured from the employer or fully insured from a number of third-party carriers who are in the process of trying to create options. The plan has to be substantially equivalent, and the rules list a number of factors. Leave has to be allowed for essentially the similar reasons, and the cost cannot be more to the employee than it would be under the state law. And the plan has to provide an internal appeals and reconsideration process. There's plenty of companies out there working on what that will look like. The issue is that under the current rules, and I actually thought this was a typo, but I've been told it's not, is that you can't even apply for a private plan exemption until January 1, 2026. And they may not be effective until April 1st, but you're paying premiums starting January 1, 2025. So you're going to be paying premiums into a program you may not even use. And then claims can start to be made in early 2026. And unless they're approving these in rapid fashion, you're not going to know if your private plan is even approved. So this is an area of the rules I think that's ripe for tweaking. as we move forward. And then there was nothing new in the rules about fraud, right? This was in the legislation that the only penalty is disqualification for 1 year. And it says the DOA may demand repayment of benefits, but it's not a requirement. Quite frankly, it would seem that fraud for this program would be insurance fraud, right? But it's not treated as such. Oh, you sit out a year and then you can just keep reapplying. And there's nothing in the rules about repeat offenders. So if you're caught with fraud 2, 3, 4 times, it's still the same penalty. It's not a permanent disqualification or anything really significant. So another area of the rules that perhaps will be dealt with.
One thing that I just wanted to add, Steve, in terms of undue or substantially equivalent, excuse me, just to make sure that we hammer home this point, the fact that businesses are going to be paying starting January 1 of 2025, it's going to be a good 16 to possibly 18 months before they're even going to have a chance of being exempt with a private plan. For a lot of employers, especially the bigger employers, that's going to be millions of dollars paying into a program that they will not even reap the benefit of at the end of the day, because they're going to be ending up, it's going to be more advantageous to them to eventually opt out. So that
and potentially employee deductions, right? Because let's say an employer wants to offer a private plan that costs less to the employee or is free to the employee. That employee may see deductions in their paycheck for over a year.
Exactly. So there's going to be a good 16 to 18 months. And why I say 16 to 18 months is even if you are approved on April 1st of 2026, and that's when it's effective, the rules state that it's not going to be it's not going to be going into effect until the quarter after that. So even though it's April 1st, you're really looking at July 1st in terms of, or whatever that scale is in terms of whenever that next quarter is, in terms of the additional benefits that are going to be having to be paid again for a plan that a business may not even use at the end of the day. So I know that is one thing that we have talked about with some other advocates, and I know Peter beat me to the punch there in terms of saying that in the chat. So I really appreciate that, Peter. And I do see the other comments and questions that we will get to answering at some point in time here once we get through this section. So I didn't forget about you, I promise. But Peter's exactly right. That next quarter implementation, if you will, is really going to be stretching that to a good 16 to 18, 19 months whenever that next quarter is.
This is why we need everybody participating in the rulemaking process. Okay, let's talk about the actual benefits, because it's quite a complicated calculation. But I highlighted in yellow here. These next few slides I took from the Department of Labor, but this yellow portion I obviously added because the rules say that wages received from any other employer should say from whom the covered individual is not on leave. There's no reduction for that. So there are situations I could see where somebody's still receiving wages from maybe a prior employer, and then they've ended up taking leave with a new one. But there's certainly a scenario where somebody takes leave saying, "Well, I can't, I can't do construction work, but I can go wait tables on the side," and there's no deduction for having a second job, right? So the rules contemplate double dipping. There's also no reduction for receipt of wages from an employer's short-term disability policy. And so, most short-term disability policies provide anywhere from 50% to 100% of wages replaced for a certain period of time. So you could go out, get paid leave from the state, and get your short-term disability benefits, and actually come out ahead and make more money on leave. That's going to depend on the actual disability plan, because disability plans typically have some reductions for the receipt of other benefits. But again, another area in the rules that I think needs to be tweaked with that. But this is how it's calculated. There's tier 1 and tier 2, using the state average weekly wage. And at the bottom, I put in what it was as of July 1 last year. We'll get the new number in a few months. But you can see how this has gone up dramatically since 2019. And COVID obviously and inflation had some reasons for this. But we're now over $1,100 for the state average weekly wage. And so tier 1, right, you can see this calculation here. If it's 90%, that's equal or less than 50% of the state average weekly wage. And then when it's more than that, it's 66%. And there's a benefits cap at that state wage. And if I've lost you, good, because it's very complicated. And I don't quite understand it myself, which is why I use the DOL slides coming up. But it's that average weekly wage that's going to matter. And again, we get that number each year. So this comes straight from the DOL. These are their examples of calculations. They actually use the 2022 state average weekly wage in some instances, and then the 2023 average weekly wage in others. So it's very confusing, but I'm going to use their slides because I don't want to get it wrong. And there's 3 examples, right? Where we've got one person earning $57,000 a year, one person earning $29,000, and one person earning $78,000. And these 3 examples sort of show where employees in Maine can expect to come out. Higher earners, you're not going to get much of a benefit. Middle earners, you'll get some, pretty substantial wage replacement. And lower earners, you'll be getting almost 100% wage replacement. And so this sort of middle earner, $57,000 a year, you can see the tier 1, right? It's 90% up to 50% of that state average weekly wage. Tier 2, 66% of the earnings exceeding that. And so we get a total of $855. This individual was earning $1,096. So not a full income replacement, but a pretty substantial chunk for the paid leave. This next example, someone earning just under $30,000 a year, you can see based on where the calculations fall that this person's average weekly wage was $566. On paid leave, it would be $505. So not full replacement, but pretty close. And as that state average weekly wage changes, you can expect that, particularly in the $25,000 to almost $35,000 a year earnings range, you're getting a good chunk of the wages replaced, which is a good reason to take the leave. It's a little, then you've got the self-employment factor and the fact that you could take leave for your self-employed job and then go get a side job and there's no deduction. And if it's fraudulent, there's really no penalty. You just got to sit out a year. So there's a lot that's going to be determined as this gets rolled out. And then the higher earner, I think you see, because you exceed that cap, right? So you go through all these calculations, it should be 1122, but wait, the state average weekly wage is 1103, so that's capped. And this individual is earning $1,500 a week. So you're not getting a full wage replacement. And as you go up from there, right? If you earn $100,000, $200,000 a year, your benefit is always going to be capped at that state average weekly wage. So, if you go from making $2,000, $3,000, even $4,000 a week down to $1,100, not a great replacement. You're paying way more in to the system than you'll ever get out. So this is really a benefit for lower wage earners. But at least it's something, I suppose, for those who would support this program. So I don't intend for everybody to be math experts. You can go back, refer to those slides. But the 3 examples are to show you sort of who benefits and who doesn't under this program. So with that, just sort of high level summary. Again, pretty much everybody's covered. Leave is immediately available. And we've got this anti-retaliation provision that is really tricky. I think we're going to see claims about that, because if you're not bringing somebody back with them because they're a new employee who took the leave, it's exclusively because they took the leave. I mean, that is retaliation. So I'm not sure how the authority will deal with that. And then we have to wait to see what shakes out with private plans, and maybe the deadlines will get a little more reasonable with that. And we'll talk about this. We'll answer questions in a little bit. And then to scare you a little bit more, some things that the city of Portland's working on, including increasing minimum wage, universal basic income, and establishing their own DLL. So if you've got employees in Portland, good luck. That's all I can really say. So with that, Mindy, we'll take you through very quickly some federal changes.
Yes. So I'm going to start with the Pregnant Workers Fairness Act. The EEOC issued some regulations that go into effect on June 18th of 2024. I went to a presentation on this last week that was an hour and a half long. I'm only going to spend a couple of minutes on this, but I encourage you to dig into the regulations. They're lengthy. There's a lot of information in there. I'm going to hit the highlights. There's a lot of information on these slides. I'm going to throw some additional information at you, but just to give you a broad overview. But again, I would encourage you to dig in and look at the regulations, because this is going to impact all employers, and it in many instances will be difficult to deal with. So the PWFA requires employers with 15 or more employees to provide reasonable accommodations for workers' known limitations, and this is both physical and mental limitations, if they're related to pregnancy, childbirth, or related medical conditions, unless it would cause an undue hardship. And the undue hardship rule is the same that you would deal with under the ADA, so that's not new. And once an employer is aware of these limitations, the employer is required to engage in the interactive process to determine what may be a reasonable accommodation. And the individual only has to identify the relevant limitation and the need for an adjustment at work to trigger an employer's obligation to engage in the interactive process. So they don't have to file anything or use any magic words. It's similar to the ADA. They just have to tell you that they have a limitation and they need some adjustment. Also, under the final rule, the EEOC has added union representative to the list of employees who can seek an accommodation on behalf of the employees. So you want to, make a note of that. And so the final rule covers limitations related to abortion, lactation, endometriosis, infertility, fertility treatments, migraines, morning sickness, gestational diabetes, carpal tunnel syndrome, sciatica, high blood pressure, miscarriages, and postpartum depression, among other things. So the list is really, really broad. It also covers pre-existing conditions that are exacerbated by pregnancy or childbirth. And the physical or mental condition that leads an employee or applicant to request an accommodation can be modest, minor, or episodic. This is a stark contrast to the ADA, where conditions that are temporary and non-chronic don't qualify as disabilities. And so the final rule reminds employers that the PWFA is intended to cover conditions that do not rise to the level of a disability. So a big difference between accommodating somebody under the PWFA and under the ADA. And so the EEOC has given some examples of accommodations that would be reasonable under the circumstances: rest breaks, sitting, standing, time off for appointments, temporary reassignments, light duty work, telework. And the final rule states that employer may obtain medical documentation only if it is reasonable under the circumstances to determine if the employee has a qualifying condition and needs an adjustment or change at work due to the limitation. So you cannot be requesting documentation in all circumstances. The final rule limits reasonable documentation to that which is the minimum sufficient to confirm that the physical or mental condition underlying the employee's limitation confirms that it's related to, affected by, or arising out of pregnancy, childbirth, or a related medical condition, and states that the change or adjustment to the job is needed due to the limitations. And I also want to note that the final rule includes a blanket prohibition against requesting an accommodation in 5 instances. So when the limitation and the need for an accommodation is reasonable, is obvious, you can't request one. When the employer already has sufficient information to support a known limitation related to the pregnancy, when the request is for one of the 4 predictable assessment accommodations, which we'll discuss in just a minute, when the request is for a lactation accommodation, and when employees without the limitations under the PWFA already receive accommodations under the employer's policies and procedures. So there's a blanket prohibition against requiring documentation in those five instances. See if you can move on, because I'm going to cover part of that in another slide. Under the PWFA, a qualified employer applicant is not limited to those individuals who can perform the essential functions of the job with or without a reasonable accommodation. So this is a big difference from the ADA. The PWFA also includes employees and applicants who cannot perform the essential functions of the job for a temporary period of time if the individual is or is expected to be able to perform the essential functions of the job in the near future, and the ability to perform the essential functions can be reasonably accommodated. The final rule defines temporary as lasting for a limited time, not permanent, and may extend into the near future. The final rule defines near future as generally 40 weeks from the start of the temporary suspension of an essential function. So that's not hard and fast. It's generally 40 weeks. So you may have to allow an employee who qualifies not to perform the essential functions of their job for 40 weeks. So for example, if you have a nurse who has certain lifting restrictions due to their pregnancy or medical related condition, you may have to tell them, you may have to allow them not to perform their lifting duties for that 40-week period of time. So it can create quite a problem for employers when they need to accommodate these pregnancy-related conditions. And once the employer returns to work from pregnancy or childbirth, the clock restarts, and you have to once again consider whether or not there's a reasonable accommodation that would require you to temporarily waive the requirement that the employee perform the essential functions of their job. And this rule applies regardless of whether the employer provided the same or a different accommodation either prior to or during the employee's pregnancy. So this will be very burdensome for employers, so you want to familiarize yourself with it. And so let's move on to the next slide, because I know we're really short on time here. So there are 4 specific accommodations that are deemed reasonable under the rules, and they are referred to as predictable assessments. And so the EEOC presumes that these 4 accommodations will not impose an undue hardship, allowing an employee to carry or keep water or drink, allowing an employee to take additional restroom breaks, allowing an employee to work to stand or sit or vice versa, and allowing an employee to take breaks as needed to eat and drink. And so the final rule states that an employer's delay in providing the accommodations identified as predictable assessments will virtually always result in a finding of unnecessary delay and will be a violation of the PWFA. So, just reading through this kind of scares me. And then the other thing I want to point out is that the EEOC's final rule identifies 5 prohibited practices under the PWFA: failure to provide a reasonable accommodation, requiring an employee or applicant to accept a reasonable accommodation, denying equal opportunities, requiring the employee to take leave when accommodations are available, and taking an adverse action against an employee for seeking or using a reasonable accommodation. And so I know I threw a lot of information at you in a short period of time, but the slides will be available, and I can also provide you with the additional information that I went through that is not included on the slides, because there's a lot of stuff you need to be aware of. Also, OSHA, just quickly, OSHA has a new walk-around rule. Under OSHA's new rule, employees may designate a non-employee third party, including a union representative, as their representative during an OSHA inspection. And this applies even if it's a non-union shop. And the new rule states that these non-employee third-party representatives don't have to have any special credentials. And notably, the final rule doesn't provide employers with a mechanism to object to the selection of a non-employee third-party representative. No ability to do that. So as employers, you want to make sure that your frontline managers are prepared on what they need to do if OSHA shows up for an inspection, and especially if they show up and demand that a non-employee third party be designated as an employee representative during the OSHA inspection. So you want to train these frontline managers so they know what to do and how to deal with these situations.
All right, thanks, Mindy. And the federal government was really busy this spring. So we got the OSHA rule, the pregnant workers rules, and the non-compete ban. And we also got the new FLSA exemption thresholds, which will take effect on July 1. There's 2 increases, right? July 1 and then January 1, 2025, where the really big jump happens. And then we've got new thresholds also for highly compensated employees. And so how this squares here in Maine is because Maine was previously higher than the DOL threshold. Just 10 days or so ago, the Maine DOL announced that they'll enforce the new federal level, right? So you can see up till July 1st. Then we've got the jump to the federal level on July 1st this year, and then again increase to January 1. And the federal threshold will be adjusted every 3 years. Maine was talking about doing this every year, but we're going to go to the federal level at this point, unless Jake knows something I don't know.
Yeah, that's what I got too as well, Steve.
Okay. But given the impending increase in July and then again in January, it's really important that you want to look at your salary bands across the positions and determine what the impact will be on a potential increased overtime. So if you haven't done that, start doing that now, because it's a pretty significant jump from where we are right now. And then just a few cases to point out. Mindy will take us through the Supreme Court just ruled.
Yeah, the Supreme Court recently ruled on an issue about what constitutes an adverse employment action under Title VII. This was a decision revived after a female police officer's claim that a forced job transfer to a less prestigious position with the same pay but different hours and responsibilities. She claimed that it was an unlawful employment action based on sex. And the Supreme Court unanimously, and that's unusual, they unanimously held that employees challenging job transfers do not need to show that they face significant harm, just they face some type of harm. And so as a result of that, a job transfer to a less prestigious position, even with the same pay and benefits, can constitute an actionable adverse employment action. And I think this rule is particularly problematic for employers where they want to separate a complainant from somebody who complains about harassment from the alleged harasser, because oftentimes somebody is transferred in order to separate them. And if you do that, you risk the complainant saying that, well, the transfer was to a less prestigious position. So you want to be cautious about who you transfer and where you transfer them to.
All right, and then I pulled out this case, which came down in September last year, just because it's a good lesson in being mindful of the language we use in the workplace. We're used to seeing these discrimination cases where there's, a racial epithet or some sort of slur used. Here, the language was one employee called someone else an evil man, and the district court in Maine determined that that was particularly loaded because it was describing a Muslim American, and that was enough to get past summary judgment for the plaintiff employee. So, without diving into the sort of facts of this case, just know that it's not always the language that we've been taught to look out for. Sometimes it's seemingly the innocuous stuff that can have a lot of liability. And so lastly, no surprise, Littler conducts this nationwide survey every year, and 87% say they're concerned about managing divisive political beliefs leading up to the election. Probably not a surprise, and that we saw a huge increase of employers reporting requests for leaves or accommodations due to mental health issues. Again, increase in litigation, increase in NLRB and DOL activity, all of these, sort of jibe with what we're seeing locally here in Maine. So there's a full report. We're happy to email it to you if you want to contact me or Mindy. But with that, I know there's some questions in the chat, so maybe we can take a few minutes and turn to those.
Yeah, I know we only have a couple minutes here, but I do want to address these questions. First question, paid family medical leave, less than 15 employees. The language seems to say may be paid by the employee, not must be. I believe that's, correct me if I'm wrong, Steve, but that says to me just the option for employers to pick up the bill if they want to.
That's right.
So it's not strictly just the employee that has to. The employer may foot that bill if they decide to do so.
Yeah, the difference would be that the employer, if it's less than 15, doesn't pay their 0.5%, but they're free to pay the employees 0.5% for them if they
want. Janet asks, also, if it runs concurrent with federal FMLA, which we can ask for medical certification, how will that work? I think that's a great question and something that's probably going to have to address as the rulemaking process continues on. So we're really going to be in tune, and we urge you as well, Janet, to take part in that rulemaking public comment process about that. Peter brought up in the undue hardship section, section 5, paragraph D. Just going to read that quickly just to bring that up. Section D says an employer may not claim an undue hardship with respect to the scheduling of foreseeable leave if sufficient notice has been provided pursuant to paragraph A, unless the employer establishes that in the specific context of the employer's business, the amount of notice provided was insufficient. So that just goes into really the overall state of how hard it's going to be for these businesses to prove this undue hardship. So Peter's exactly right.
but that's only with scheduling. So I want to be clear that that section is only if the undue hardship is based on a scheduling issue. If it's undue hardship because of the operation of the business more broadly, or like for my example, someone's got to care for the kids, you still have that option. So that's, maybe it can be clear, but it's limited to just the scheduling.
In terms of the exempting federal work study students, universities supplement with their own funds for work study. What about those students? Again, I think that's going to be something that's really going to have to be touched on as the rulemaking is going forward, because you're absolutely right that wasn't touched at all. So again, encourage you to reach out to the DOL with those comments. Maybe geared toward Mindy here. Does the Pregnancy Act cover spouses who may need to take time for pregnant spouse?
No, I mean, it certainly isn't intended to do that, and I don't believe there's a way that somebody could read the statute that way. It's intended to accommodate employees' medical conditions related to pregnancy, childbirth, or related medical conditions. So
you could take Maine paid family leave
Yeah,
to care for a spouse who's pregnant.
Exactly right.
But I think Jen is probably worried about the accommodation piece. And you should not have to accommodate the spouse.
Awesome. Well, those are the questions that did pop up in the chat as we wind down here. 2 minutes over. I think we did all right with the amount of information that was covered. We know we threw a lot at you in a pretty short amount of time. So these slides are going to be posted for you to go back and review, as well as just another reminder, in the near future, we're going to be doing a paid family and medical leave specific rules update webinar that's going to go into much more deeper dive into what these rules mean. Again, I can't say enough that really participate in that paid family and medical leave public hearing process and comment process. It's really advantageous for businesses to reach out to themselves to the DOL with their comments and concerns. So I really urge people to do that. If you do have any questions for me, Mindy, or Steve, please, Steve just threw email in the chat for both Mindy and Steve, so I appreciate that. Feel free to reach out to us at any time. My email is jlachance@mainechamber.org. And finally, again, really want to thank our sponsors for this event. Couldn't have done this without them, especially our presenting sponsor, MEMIC, and of course, Littler Mendelson, for giving us Steve and Mindy to help out with this really informative forum here for human resources updates. So thank you all for attending. Hopefully see you at the next Maine State Chamber webinar and event. Next Tuesday is going to be the healthcare forum that's going to be sponsored by Harvard Pilgrim to talk about housing issues in relation to the healthcare world, which is something, housing is obviously a very pertinent issue for a lot of things, especially in the healthcare world right now. So thank you all, and we really appreciate your attendance.